to single-handedly saving our clients.
One arm, Diana.
Inside joke.
So,
Well, inside your arm.
on one of our previous podcasts, we talked about wanting to do, sort of another case study of a case we did recently where we don't have a judgment, but there's a number of factors that are concerning in understanding certain aspects of the law. So just to set this up, this is a case where it involves an allegation from a young person, so under the age of 18, that an older person had, on several occasions over the course of a summer, brought her into his trailer and committed some sexual acts. And a lot of the defense was factored around the environment in which this is alleged to have happened. This was alleged to have happened during the day in full sunlight where people are all out and about.
With all the windows open.
Clear area within the trailer that the windows are open, they're not closed. So the notion of sort of privacy and isolation is really out the window on that one. But there's a couple of interesting factors you deal with on cases where you have this allegation and on its face it has this either intoxicating or insidious sort of lure to saying, why would somebody lie about this if it didn't happen? Why on earth would they ever bring this up? So what's their motive to lie? And that's juxtaposed with somebody saying, I didn't do this. I really didn't have the opportunity to do this, and it's such a high-risk act. Like, what, you think I'm insane?
Right.
I didn't do it. So that's sort of an interesting fact scenario, and I think it's important for us to talk about a few things. So to break it down, we have our whiteboard.
It gets kind of complicated in terms of motive. First of all, everybody kind of has in the back of their head, they want to know, why would somebody lie? Mm-hmm. So
Always.
It benefits the defense if we can point to a motive, but there isn't always a clear motive. And this is one of those cases where we were forthright. We're not suggesting a motive. And there's some really good case law when defense doesn't put a motive on the table, that it's not proper to ask, why would the complainant lie? And there's really strong case law on that. But when the defense does suggest a motive, that can change things, and it gets really complicated. There's a difference between no known motive to lie and a proven absence of motive to lie.
Yeah, so let's say that slower, and I'm not as optimistic, or I'm not on the same level of happiness with the case law as you are. Yeah. But let's first talk about...
My understanding of the difference is that an absence of motive to lie, an unknown reason why they would lie, basically just takes it off the table. Even if defense suggests a motive, and the trier of fact, be it a judge or jury, is like, I'm not really sure about that. It just takes it off the table. But it doesn't bolster the complainant's credibility if they don't believe the motive.
Repeat that.
Yeah. So,
and then I want to muddy the waters with you reading a certain paragraph from a decision.
So, and this is prior to a decision that came out, which is kind of, I think, muddied the waters a little further. But prior, you could suggest a motive to lie, and if the trier of fact, be it a judge or a jury, says, I'm not really sure, it just takes it off the table in terms of, but it does not bolster the credibility and add to the credibility of the complainant if they don't believe that motive existed. Then the difference is a proven absence of motive generally amounts to the prosecutor showing that, and the evidence of the complainant showing that they in fact suffered from making the allegation and had zero benefit from making the allegation, which can then be seen as a proven absence of motive.
Which is very strong.
And that's very strong in terms of bolstering their credibility.
Okay, so I want to go on to some things, but first of all, let's just read from Ignacio, which is a decision, a 2021 decision. We're
going to read from BAT, which is cited in Ignacio.
Cited in Ignacio. Yeah. But so I just want to frame this. So it's a case from 2021, the Ontario Court of Appeal. They're referring back at paragraph 40.
I'm just laughing right now because I'm looking at Max's face, and he's just like, okay, I'm going to have to get all these citations from you.
We'll get the citations.
We'll take care of you, Max.
I promise. Yeah. But paragraph 40, take it away. The court is citing another case and reading something important. Right. So go ahead.
So this is important. This is more muddying of the waters by Justice Doherty, who's a great guy, but this is dangerous what he talks about here. So BAT, for Max's benefit, is a 2000 case, Court of Appeal.
BATTE.
BATTE 49 OR 3rd 321. So, no problem. Now back to our regular programming. In Bat, the appellant was convicted of sexual offenses in relation to 2 complainants. Among other things, though, the appellant argued that the trial judge erred in instructing the jury that they could ask themselves why the complainants would have fabricated the allegations and subjected themselves to the trial process. Now, at trial, the defense had argued the complainants hated the appellant and their hatred motivated them to fabricate the allegations. So here's how Doherty resolves all of this. He confirms, and I'll read this slowly because it's important.
Yeah.
Juries are entitled to consider whether there is an absence of motive to fabricate, and he identified problems for trial judges to avoid in instructing on this issue. And he says, this is at paragraphs 120 and 121 of the Bat judgment again, it is difficult to think of a factor which, as a matter of common sense and life experience, would be more germane to a witness's credibility than the existence of a motive to fabricate evidence. Similarly, the absence of any reason to make a false allegation is a factor which juries, using their common sense, will and should consider in assessing a witness's credibility. And what he goes on to say, and this is the important part, what must be avoided in instructing a jury is any suggestion that the accused has an onus to demonstrate that the complainant has a motive to fabricate the evidence. I'll repeat that again because, again, it's critical.
And also kind of confusing given the earlier statements.
Right. What must be avoided when you're instructing a jury is any suggestion that the accused has an onus to demonstrate that the complainant has a motive to fabricate the evidence, and that the absence of a demonstrative motive to fabricate necessarily means that there was no motive, or finally, that the absence of a motive to fabricate conclusively establishes the witness is telling the truth. That's a lot in that paragraph.
Mm-hmm.
And then,
so let's break it down.
And then the underline, the last sentence, the presence or absence of a motive to fabricate is only one factor to be considered in assessing credibility. Diana, over to you. Break it down.
Okay, well, first of all, it comes across as very convoluted because they're saying that a prosecutor can argue that there's an absence of motive, even if not a proven absence of motive.
Right.
And yet they're simultaneously saying that there's no onus on the accused to show a motive.
That's right.
So you're saying, oh, well, you know, and the reality is it's the previous case law, especially a case called Cusk, which is fabulous. So that it's so insidious when you ask an accused person why would they lie.
Of course.
Because it's such a subtle reversal of the burden of proof.
It's not subtle. It's a complete reversal.
That people are confused by it all the time.
Right.
So I don't, the way it's worded, and I don't know if he could have worded it better to make it more clear, but the way it comes across and the way it's being cited is, it's to me very contradictory, where they're saying, the accused doesn't have to prove something, yet the prosecutor can put it out there.
Right.
And then, of course, that puts the burden on the accused to try and counter it.
Yeah, counter it.
So that's the problem with that. And the problem is that there are so many cases where it's really unclear. And in fact, we've talked about studies on why people who admit that they've lied, when they're asked why they did it, the second top reason was they don't even know.
Right.
So if they don't even know, how is the accused person going to identify it or prove it? Because there is no clear motive. And at what point can you say a prosecutor has gone from showing that there's an absence of motive to a proven absence of motive? How do you decide where that line is?
Let's just that's an important thing. But let's just throw in for 1 second the definition of a proven absence to motive.
That would be helpful.
Just so we have that for everybody. And so a proven absence of motive is a situation where the Crown has established, and you alluded to this earlier, that the Crown has established at a fairly high threshold that there is a proven absence of motive to fabricate. And that type of evidence can take several forms. So the complainant by coming forward with an allegation has, as you said, suffered. And that could be...
And gained nothing.
And gained nothing. And not only gained nothing, lost something.
Lost, yeah.
So this could be within a family where coming forward with an allegation, it has broken the family apart. Mm-hmm. As a result of breaking the family apart, the complainant may have become ostracized and therefore disconnected to various family members or maybe all family members. That they have suffered maybe the loss of friends or important friendships.
Social circles.
And that it wasn't unpredictable that this would have happened. It was pretty clear that making this accusation in the beginning, that the complainant was aware that this was going to be...
Stuff would happen.
...difficult for them. Yeah.
That's an excellent point. So what you're saying is the complainant was aware at the time that they came forward that by doing this, there will be repercussions for coming forward with this allegation that will bring apart negative implications for the complainant. If that is established, that, as it says in the case law, Ignacio and SSS, I guess, that it is a fairly strong platform on which the trier of fact, whether it's a judge or jury, could find that the complainant is indeed telling the truth.
And
that can carry
credible.
The day. Is more credible, and that can carry the day.
It's a factor, though. Let's remember that.
It's more than a factor. The specific language, and this is something we got to be really clear about. Let me find...
Although you cannot say that the willingness to testify shows...
equals
an absence of motive. Like just the fact that somebody's willing to testify cannot be used to bolster their credibility.
Right.
Yeah, so let me just find the exact language because it's extremely important language. In fact, I think you said it's a strong platform in which to conclude that the complainant is telling the truth. And I think that's an SS, which speaks about it. And SSS. Yeah. And we'll give the quotation for that to be as well. That means it's more than just a factor to consider.
It's a big, big issue.
But again, it is a very difficult situation for an accused person to try and identify because they can't be inside of a complainant's mind, so it's difficult for you to figure out what somebody's motives are. And in fact, there's a fair bit of evidence that people are very, very bad at understanding their own motives. Human beings in general tend to do a lot of things without really understanding their motives, and maybe in hindsight later on they can figure it out, but for a third party to try and figure out why another person has a certain motive to do something is an incredibly difficult situation. It's almost like asking somebody to prove a negative.
Well, yeah, it's a crapshoot. How are you supposed to know?
Okay, so I think I'm going to harp on this for this episode because it's extremely important for, people ask us questions or viewers about evidence, and they like when we do this. So let's divide this up. If the Crown can establish on a high threshold an absence of a motive to fabricate based on the evidence that we've suggested, that's a strong platform for a court to consider that the complainant is credible, period. It's more than just one factor.
Right.
It is. Because on the other side, you may have a denial or a consent issue, but regardless, it can carry the day. It is, as they've said, a very strong platform.
Well, in the credibility decision-making process, it's not determinative, but it's a big factor. The test still has to apply. All the evidence still has to be weighed.
So let me just read this, because I want to...
It puts the defense, I think these decisions put the defense a little bit more on warning, too, that if you're going to suggest a motive, be very careful that you've fleshed out your motive well.
Well, what the court tries to do, and this is where we get into some complication here, is to say where an accused specifically does not raise an issue of motive to fabricate, then a lack of motive to fabricate could be neutral, but it's not.
Right.
Okay? And I want to be careful about this, okay? Because as long as you've known me, I've said you need motive to fabricate, right? Have I not?
Right, yeah.
That's one of the things we look for, but yeah, right. it has to be very careful about how you suggest it, and also not just what you're suggesting, but the timing, because if you allege that a motive was fabricated, the motive to fabricate occurred at a certain moment, then even if it was a moment in the past, it's called recent fabrication, and it opens the door for the Crown to call prior consistent statements that could show that the allegation was made before you're alleging the motive occurred.
Correct, but as
and
a
I know that starts getting complicated, but this is, I think, important for everybody, because this is one of the big things. Is like everybody, who hears an allegation, if you try to say, well, how do you know it's true? They go, why would they lie?
That's the first
Everybody
question.
always, that's the very first question always asked.
And in fact, we cannot be stupid and think when we're running a jury trial, they're not thinking that.
Of course they're thinking
And
that.
some judges are thinking about it no matter what.
Exactly.
Okay? So let's look at paragraph 31 of Ignacio and onward. I just want to get the language, and then I want to just discuss this for a moment. Because we deal predominantly with cases where we, on balance, establish a fabrication, where we can say in a statistically significant portion of our cases, we have shown false allegations, and we're confident in that. We don't say that lightly. Okay?
Right.
No.
Now, the first part of the appellant's argument is that the trial judge made a positive finding that the complainant had no motive to fabricate when the evidence did not permit him to do so. Okay? So this was on appeal. While the cases leave open the possibility that the Crown can prove that a complainant had no motive to fabricate, they set a high bar for proving no motive to fabricate. This is because of what you say, motives can remain hidden, or there may be no motive at all. Let's pause. So, you raised an excellent point, and we've discussed this before when we had that study, and this is why we're desperate to have some academic research now, rigorous academic research, because people can come forward and say, at the end of the day, when it's a false allegation, they don't know why they made it. Mm-hmm. So we can't presume we understand psychology of anybody to any certain degree that we're going to ruin people's lives. I think we have to be very careful as to what people's hidden agendas and motives are. But the court says clearly that there is this high bar. If the Crown has proven that the complainant had no motive to fabricate, the Crown has a powerful platform to assert that the complainant must be telling the truth. Bartholomew at paragraph 21. However, in most cases, the trier of fact will be faced instead with an absence of evidence of any motive to fabricate on the part of the complainant. So, we know there's one category. Right. If the Crown is able to establish that there is no motive to fabricate, and we based it upon what we spoke about, and I know I'm being repetitive, this is a powerful platform for the Crown to assert that the complainant must be telling the truth. Dangerous, right, and live issue at play in criminal sexual assault trials. Now, let's go back. Where there is not that proven by the Crown, and the defense has raised an issue to fabricate, saying the complainant hated him and wanted to achieve X, Y, and Z, the absence of and let's say the trial judge or jury would reject that. We don't know what juries do, but let's just presume we do, that they rejected that. In an instruction to a jury or a judge's instruction to themselves, they still can consider no motive to fabricate as one factor. Mm-hmm. And Ignacio reinforces what has been in place for well over 23 years, that although an accused has no onus to demonstrate that the complainant has a motive to fabricate evidence, the absence of a demonstrated motive to fabricate means that there was no motive, but the presence or absence of a motive to fabricate can and is only one factor to be considered in assessing credibility. So here's the problem. Mm-hmm. Whether you assert it or not, whether you establish it or not, right, it's still one factor. And this is why I've said in these cases, and we've been doing this for 5-6 years
now. What's an argument about weight? How much weight can be put on it? How much weight do you
attribute to it?
And these cases are dangerous about how much weight can be put on it, even when it's not a proven absence.
What does it mean it's one factor? What the does that mean? The reality, it means if you can't establish some sort of fabrication, and at best you're relying on, a denial, you're
that it almost automatically reverses the burden of proof.
And they specifically say you have no onus. I repeated this. Right. There is no onus to disprove a motive to fabricate or prove a motive to fabricate, but the absence of a motive still can be considered as one factor in assessing credibility.
Right. So we worked on a case that had that difficult aspect where there wasn't an obvious motive to fabricate, and we didn't suggest one. So we don't know why she's doing it.
Why?
Right?
We don't know.
But there were some other combinations that create some really difficult problems for an accused person, especially in cases where it really is just a he said, she said kind of case.
Yep.
And so one is possibilities, which I'll get into, and the other is opportunity. So this is one of the things that we addressed in the case that we were working on is, he's saying, well, sure, I probably was alone at some point or another. I'm not saying
denying it. Yeah.
Yeah, you're not saying it could never have happened, right? But just simply because, and there was a good case that I think the Crown brought up as well, that talks about opportunity and how you can't make assumptions. Just because somebody had an opportunity, you can't assume that they would have taken the risk to take advantage of that.
Right. Or that type of offender would necessarily engage in high risk
and
activity.
I think that's the CG case had a really good paragraph on that, saying that you can't assume just because people who do commit sexual assaults do engage in high risk behavior, just because
it's there.
Burr, you drew our attention to paragraph 46 on CG,
Right.
and it might be helpful if you just sort of read it a little bit, and then we debate it. I'll give you my CG afterward. It's exactly what you're talking about.
Yeah.
So this is Regina versus CG. It's 2021 decision. OJ 6434, but we'll have the citation.
We always do.
But paragraph 46 is important, and then I want to frame this argument and tie it back to the motive issue, tie it back to our case study, and just establish how hard certain issues may be.
Yeah, and this involves like a stereotype and assumption about what real rapists would do, which are just as insidious as assumptions about what real victims.
You're going to like the paragraph.
Right. Yeah, I know.
You're going to like this one.
Yeah.
But here's the preview to the paragraph I'm about to read. I love Justice Watt's words. This is from...
I've always enjoyed Justice Watt's writing.
He's great. This is a case of John, 2017, Ontario Court of Appeals, 622. This phrase summarizes this episode. Justice Watt says, "The distinction between absence of evidence of a motive to fabricate and absence of a motive to fabricate is not easily digestible." Like that just sums it all up. It's hard to understand.
Yeah, well, that's what you were saying, Diana. Right. Yeah. You know what? Credit to Justice Watt. I mean, his writing's always been amazing. Right. Not that Doherty's writing isn't excellent. No. I mean, he's a brilliant thinker and writer, but Watt puts it in plain terms. So how do you digest
that?
How
do you explain that? How do you explain that to a jury? How do you explain that
even
to
judges?
Even to a judge,
saying. Yeah. It's very difficult. Now, just go into paragraph 46.
I'm going to go into 46.
And then I want to tie this all together.
Okay, I'm going to read a lot of this because it's important, and I'll read it slowly. So, this is, again, from CG.
Sorry for boring you with this, but
this is important stuff, folks. If you don't want to listen, tune out now, but I suggest you stay.
No, don't say don't tune out.
No, I said they won't tune out. They're going to stay because this is like, we've led up to this moment. This is the moment of the podcast. I hope it is, at least.
No, it's not, but it's close.
It's close. It's getting there. It's like the sequel, almost.
Stereotypes about accused people? Is that where we're going?
I'm not telling you. You have to listen. Okay, paragraph 46 from this judgment. I'll pretend to be the judge now. "It is unclear to me how the trial judge may have used his view on this point in deciding this case. It cannot reasonably be disputed that some sex offenders take incredible risks, and trial judges are entitled to reject an implausibility argument that is based on the unlikelihood that the accused would have taken the risks required to commit the offense with which they are charged." Interesting. Going on. "But here, the trial judge appears to be expressing a universal truth that all sex offenders take incredible risks," red flags, folks, "which would constitute an appropriate stereotype about how sex offenders behave. Even if the trial judge was not intending to express a universal truth, he was at least of the view that incredible risk-taking is commonplace." Where he got that, I don't know, but in any event, continuing. "If that was the trial judge's approach, then he erred in doing so." No Sherlock. Sorry, bleep that. "Not only is it arguable that this too would be an inappropriate stereotype about how sex offenders behave, judicial notice cannot be taken of such a contention as if it were a fact. Assuming such a fact could be established, it would require a proper evidentiary foundation. Yes. A third possibility is that the trial judge was relying on his personal knowledge or her personal knowledge, unless the personal knowledge experiencing as the proven fact. This would also be an error. A trial judge cannot judicially notice a fact within his or her personal knowledge unless the criteria of notoriety or immediate demonstrability are present. In either event, while the trial judge mentions the risk point in the final paragraphs of his reasons, he fails to deal with it. Of course. Over to you.
Go, Diana. I want to jot down on this one.
So just to kind of summarize a little bit, there was a high risk that the judge was using inappropriate stereotypes to say that because it was high risk, that it was more likely that the person
would commit a sexual offense.
The sexual assault, just because there's an assumption that rapists are high risk, and therefore the higher the risk that was taken, the more likely that it happened. So that's the false logic that was being employed, potentially being employed.
Right.
It was unclear because of the way the reasoning was written out. And that is a really big problem in a lot of cases, especially where somebody is accused of assaulting somebody who lived in the same home. And then, of course, the opportunity does exist.
Right.
And just the mere opportunity existing does not tell us anything about whether or not it really happened.
But isn't it scary that this kind of thought process is still taking place?
Well, I know. And there's been a number of Court of Appeal decisions that involved that as a ground of appeal, that the judge, seemed to be very clear in their wording that they found the person was guilty because the opportunity existed.
Sorry, I was on the phone just managing a bail hearing for tomorrow.
We take care of our clients.
So this is really frightening. So I just say this. So this was a very good paragraph where they said, look, there's no myth about how somebody who is a real or legitimate sex offender would behave and whether they would always engage in high risk behavior. So that's a good thing. But let's tie this into motive.
But it's also important to point out that there's stereotypes about accused people, not just about complainants.
Right.
That there are active stereotypes about accused people that infect the reasoning and result in wrongful convictions.
And there's been very good case law recently about male sexual stereotypes, male aggression. Just because there's an opportunity doesn't mean a male will take it. But all that being said, you have a case, right or wrong, okay? We're not judging anything, but you have a case where there's an allegation and on its face, you're like, everybody sits down and goes like, I don't have a motive to fabricate here. I can't see one. On its face, it seems like a reasonable accusation. Then you have an accused who, like in our circumstances, significantly older, retirement age, no history, great marriage, everything's fine, friends, in a situation, in a milieu where there's people all around, highly unbelievable that it would happen during the day, where a person doesn't even close blinds, where
neighbors come visit,
all the time without even announcing.
Right.
Nobody, goes by ceremony and knocks or calls there, makes a time. And in circumstances also where the complainant has said, whenever I was there was always people around. Not necessarily in the trailer, but in the vicinity. So it's not a case of isolation. Yeah. There's no history or real history of trying to groom or isolate the person. And so you're left with the inevitable. Why would somebody make this accusation up?
Uppercase.
Yeah, and based upon the language that we have from the Court of Appeal, you can consider, and it can be argued to say, there is no real argument here about why would this person make this up. It's just one factor I can consider. Of course, the accused doesn't have to prove a motive, doesn't have to, disprove, a motive, however way you want to put it. But
it's out there.
Maybe, I can consider that there's no absence here. And so you're really in a very difficult conundrum. How do you defend against that? Because there can be legitimate cases where for no apparent reason, somebody makes a false allegation. we have found time and time again, some people don't know why they say it. Sometimes you don't have enough information to dig to find it. Could be the complainant wants attention, and you can't get that out in the evidence. Maybe there's some other psychological, emotional issue that's satisfied by making this allegation that we don't have access to. We don't know much about these people's lives. We know so far less about a complainant's life, even more so now, because of what we're restricted in asking. So, based upon 1 hour's worth of testimony, a 45-minute statement, the absence of finding a motive in the face of just a denial where you're arguing plausibility. And this case, CG has said very clearly, I'll just raise this again, that in fact, a court can reject a defense based upon simply saying there is no possibility or it would be high risk. That in and of itself really is not much of a defense. Right. You can consider it, but it's not that much of a defense. Right. It puts a person in a very, very difficult situation when you can't pinpoint a motive to fabricate.
And you bring up a word that there was a case that I'd printed out, and it's too lengthy. I was laughing out loud about some of the stuff, but it has to do with possibilities. So you brought up that word, possibility. And there's this really interesting case, and it's translated from French, so I'm not even going to give the citation because it's just a translation, a rough translation. But that was the biggest issue, was like, if you say, well, is it possible, and in this case the prosecutor put to the accused person, was it possible this thing happened? And then the jury came back and said, well, if somebody says that something might have been possible, is that the same as saying that it's true?
Yeah, it's true, yeah.
Can that be seen as a fact? And it turned into this massive philosophical argument that was so convoluted it's unbelievable. And the Court of Appeal overturned the conviction and granted a new trial on the grounds of the jury not being instructed properly. But possibility, I've said to people before, because it's difficult to understand the language used when people frame questions, when lawyers frame questions. And it's different when you're being asked questions by the person who called you, the prosecutor's witness, that's in chief when they ask questions, and then we cross-examine. And in cross-examination, you can put things to somebody, and sometimes you must put things to somebody. And you'll say, well, isn't it true this thing happened? But I said, always watch out for possibilities, because in the end, this is your life. You want to try and testify to the things you know.
Right.
So, for me, I'm just like, is something possible? Well, you know what? I don't want to talk about possibilities. I want to talk about the things I know, right?
Not rolling the dice on that
in this particular case, and the reason I say that is because I've seen cases like this where questions about possibilities end up becoming this big trap, where then it's just like, oh, well, sure, it could be possible. And then all of a sudden that gets transformed as some sort of fact-finding.
Right.
And they're very clear that the case law on it is that, from the Supreme Court even, a possibility doesn't tell you anything about the facts in the case.
Absolutely nothing.
This is not an easy area of law.
No.
I know.
Until next time, guys, thank you. It's difficult, and I think we have to keep plodding away at how we deal with this and how we try and prevent wrongful convictions.
I know. And it's very possible people are going to love this episode. And if you do so, then like, subscribe, hit notifications, leave comments, and
send us emails again about what you want to hear from. That's really great. Thank you.
Watch it a few times. It might become more digestible, in the words of Justice Watt.
Yeah.